Inclusion, my lord, one petition related give.
My lord, may I permitted to mention for inclusion 3 minutes?
All these matters should be hard and there is a direction. Check if there is direction, why it has not.
My lord, may I permit to mention, my lord, for correction of order?
Yes, what happened?
In the order, my lord, the charge memo dated was recorded as 15th June 2024.
Wrong date.
Yes, my lord.
To be mentioned Monday. Item number 2.
Mrs. Alum is appearing for Union of India, my lord. She is coming, my lord. She may start.
And then
What is the replacement panel? How it is?
replacement panel, if somebody is not in, I have given the circular yesterday, my lord.
If somebody is
Not in the original panel, then it will be placed in the replacement panel. I ended up the circular, my lord. If your lordship kindly sees Roman 3.
Roman 3. Oh.
দিয়েছি
Yes. What is wrong? What is the problem?
Problem is this panel, I am in the original panel.
You are not in the original panel.
Yes, I was in the original panel. Lordship, kindly come to page 52.
Yes, you were in the original panel.
So question of replacement panel, my placement is not necessary. If I am not in the original panel, then I will be placed in the replacement panel if somebody does not turn up.
Turn up.
And another thing, my lord, I was scheduled caste candidate. From the
Point is, it was an employment notice of 2012.
yes, they did not dismiss my case, tribunal. They are not aggrieved by that order.
No, but they are not aggrieved by that order.
That order, their also consideration is there.
You don't want that order. You want change of the order.
Change of the order.
So
I
they-
filed review also. But on 3 grounds. Firstly, my lord, I was considered for a post. May I submit, my lord? First panel is prepared. Then, my lord, offer of appointment is given. Then, my lord,
First, the PET is done. Those
Everything
who
is over.
qualify for the PET, they
Yes.
are called for the written. After written document verification, 20% over and above the vacancies. Then a panel is prepared. Those who join, they join. If anyone remains vacant, then only a replacement panel is prepared. This is the procedure as we have seen from the circular.
Now, my lord, I was called for medical examination before.
Therefore, when the 2012 employment notice was issued, you participated, many have participated. So has anyone been appointed in that process or not?
Yes.
So therefore, if we don't know what is your position,
No, my position is I was considered for appointment.
that is all right. But finally, after the document verification was not done,
Yes, everything is over.
so you were placed in the panel.
Yes.
At what place in the panel?
Now that is not that does not appear in the.
Then
because
how can we say that you?
no,
must
I'm coming, my lord.
see the panel is in 20% excess of the vacancies. So
No,
we
I'm-
don't know whether you are in the excess or
No,
you are in the.
that is not the dispute.
Where have you said so?
Now, Lordship, kindly come to page 52 for a moment.
Page?
52.
Yes.
This is my result. That you got it. As Hirulka's candidate.
That is nothing. This is much before preparation of the
Now,
panel.
Lordship, kindly come to page 71, speaking order for a moment. What is my grievance? Page 71. Page 72 is relevant. Second paragraph. The applicant Sri Devkumar Halda may place, my lord. Roll number 7 applied for PB1 grade pay such and such against
Page number?
72. Second paragraph. Successfully qualified in the written examination followed by PET. Document verification. He was empaneled as OBC merit. I'm a scheduled caste. That is,
But this you have never disputed.
yes, that is the challenge. This speaking order is on a challenge.
Where is that?
That is the way.
The way you have, where is the prayer made in the way?
Yes. Quashing of the speaking order.
Squashing of the impugned order, speaking order does not mean that you have challenged the panel. When the panel was
panel-
published and you were shown as OBC, did you challenge the panel?
No. For the first time, panel is not published, my lord.
So just now you said I was in the panel.
Yes, they said I'm in the panel.
We are asking you to show that you were in the panel within the number of vacancies. If you were not within the number of vacancies, you can only be in the replacement panel.
No, not you kindly see within the number of vacancies. Not you kindly speaking order. My lord, panel is not published.
Then how do you know?
Only result is published. Only this. If I click
Just now we said that after document verification panel was not published. Actually, it became inoperative.
No, they don't publish panel. if we click the my roll number, I will get my result only. The entire panel is not published.
How it can be?
Yes, my lord. Lordship,
You
kindly.
have just now placed the circular which specifies the entire
Yes,
recruitment
no, my
process.
lord. Lordship, let them say. Page 52, Lordship, once again come.
Why should they say you are before the tribunal making out a case? What is your case we are asking you?
My lord, my case is that firstly, panel is not published.
No, no, no. Don't jump to the panel. You have appeared for the PET.
Yes,
Thereafter, on being scrutinized, you are called for written. You have participated in the written.
written first.
Huh?
Written first.
No, panel PET first.
No, no, my lord. Written first, then PET, then
Please
bottom.
see the procedure. You have given us that circular. See, read it, please.
That I've seen, my
Please read.
lord.
Don't just go straight to 3. Read from the top.
No, I've seen, my lord. But in fact, in this case, my lord, for written test was held.
I don't know. That is the process. We presume that it has proceeded according
Anyway,
to
my
the
lord.
circular.
Now, my lord, they
After PET written, after written, there was required to be a document verification and then only panel. For document
no, they say,
verification,
my lord, they impaneled me after medical examination.
correct.
After medical examination.
Correct.
First,
Where is the medical examination? At which stage?
after PET is over, document verification is over, then medical.
After written.
Written, yes. But before empanelment,
So therefore, you were subjected to medical.
yes,
But then was the final thereafter was document verification done?
yes, my lord. Document.
Where? Show us. Where have you said that document
No, no,
verification?
they are said in a written speaking order itself. I did not know what is my position, nothing.
If you don't know, how can you assert that you have to be in the panel? That is what
They
we
have
are
said it,
asking
my
you. It
lord,
is
in
a
the
simple question.
speaking order.
Yes, in the speaking order, they have said which you are not agreeing with,
No, as
that it
OBC,
is incorrect.
no, Lordship, kindly see,
So
OBC, I am not.
therefore, that cannot be relied upon. You say I cannot be
No,
published
no.
as OBC.
My point is this, my lord, Lordship, kindly see, I am SC candidate, that is admitted position.
So therefore, this is wrong.
That's
Their
what I was
statement
saying.
is wrong.
That's
So
the
how
challenge.
you are not relying upon it?
No, I checked.
So what have you to say? We are asking you. They are saying something which is
Yes, I
wrong.
said
What
that
is your case?
I said that SC candidate, I
You
appeared.
were in the panel. Show us anywhere where you have said that you were in the panel as an SC
No,
candidate.
no, SC.
Where is the OA? Let us see the OA.
Yes, madam.
Yes. What is your case in the OA? Unless you were in the panel, how can the tribunal direct that you should be in the panel? If you can only be in the replacement panel, we don't find any.
No, my lord.
Unless it is your case, show us from the OA.
My lord, my case is this.
Let us see your OA. We
Yes.
don't want you to
Page
submit what is your case. We want to see what is your case.
62.
Page?
62.
Yes.
এটা আগের বই না আগে earlier way. Wait, just a minute, my lord. Page 32.
62 you just now you said.
No, my lord, that is earlier way.
You have filed 2 OAs. You have
Yes.
why?
Earlier, my lord, the speaking order was directed to be passed. That's kind of page 29. I did not know as SC or OBC because they don't publish the panel in the website. Only if
No,
I
there was no panel. Till the time you approached the tribunal on the first instance, it was not your case that you were impaneled.
yes, my lord.
You said after medical verification, I don't know what has happened. They are telling me that appointment letter will be issued, but nothing has come.
No, page 29, my lord.
Page
29
of
writ petition. From the website, I got SC as SC. Page 52. From speaking order, it appears it is OBC.
Where is this website thing? Show us.
52, page 52.
No, where is the annexure?
Annexure is page 52, my lord.
Page 50, perhaps.
50 is the, yes. Yes, 50. Yes, see, lost you kindly see. Community. In speaking order, they said OBC. First,
Yes, so many appointments were also made. It is not that no appointment was made.
yes.
Panel was published. From that panel, appointment was made. You are in a provisional panel. You
They
were
never
never in
made
the
it
panel.
final. They from that panel they made appointment.
Huh?
From that panel they made appointment. They never made it final.
No. Just it is quite evident what they have done. They say panel was prepared, call letter was issued, some have been employed, and some pre-recruitment formalities are going on. You are thereafter you have been placed in a provisionally impaneled. You are not in the panel.
Yes. They never published any other panel.
Oh yes, they did. You please read the top of that page.
Yes.
Yes. Panel was uploaded on the website on 26/9/15. They have given the specific date,
Yes.
and from that they have made
Lost you kindly
appointments.
see at the top a provisional panel.
Yes,
Only provisional panel.
yes, and was operated against the vacancies. That is
Yes.
what we are
Thereafter
saying.
stay came. Thereafter stay came. Thereafter the stay
So
came.
therefore, after the vacancies, it can only be a replacement panel.
No, my then lost you kindly see that is not my case. My case was that
We,
first of all I am not an OBC candidate. Speaking order says I was considered an OBC candidate.
that is the different thing. The point is you are whether you are in a panel.
SC Lordship kindly panel. Lordship, let them say that there is another panel. Let them.
Not required. This is what can they say after this? Where is the speaking order?
Yes. In order, my lord.
We are not going to consider the entire thing afresh.
Yes. Lordship kindly come to page 71. My grievance was twofold. Page 72.
Just a minute. Yes.
Now, Lordship, kindly turns to page 51. When the date of the panel is 26/9/2015.
That panel is over, sir, because so much time lapsed. They asked you to go for a medical
that is
test
not-
again. Again, you were subjected to medical tests.
Yes.
They put you in a lower category. High Court said no question of second medical test because age has lapsed on account of delay on the part of the authorities in concluding the proceeding. Therefore, without any fresh medical test, they should consider.
Yes, but they.
Now, in the meantime, there are many who have been appointed.
But that was not the case before the learned tribunal.
No, but that is a fact you cannot shut your eyes to. That is a hard reality.
But
So
Lordship, kindly
therefore,
see-
whether the tribunal is to ignore this altogether or say that yes, in a replacement panel you should be considered. That is the only thing.
Now, another thing, my lord.
Yes.
I was considered for the post I did not apply for.
Those issues are not here.
Yes. I've stated. We have stated.
They have found you eligible for a post because your medical category was scaled down from A2 to A3.
No, I was not. A2 is the porter.
Correct.
I did not apply for the post of porter.
We don't know. We don't find from your OA.
Yes. I've stated. In a way.
Let us see.
Yes.
Show us which post you have applied for.
That was my case in the
So
way.
then the entire thing has to be heard afresh.
Yes.
All right, then we'll fix it for hearing.
I have specifically stated.
No, we are not found from your OA. Show us where is that
Yes,
fact. Let us see.
Lordship, kindly come to page 35.
You say no specific post was ever mentioned by the
They
applicant.
did not.
By the applicant.
Yes.
You never mentioned any
Yes.
post.
Lordship, kindly come to my application. I have annexed.
Please read what you have said in paragraph R at page 35.
Nor any communication was made to the applicant.
That comes after your statement that I did not make any application for any post. Don't skip that. That is also very much there. You are submitting something which is contrary to your client's case.
That is not correct, my lord. I can show.
That is his statement on
It is
verification, and you will prove it wrong. You are appearing for him or the respondent. What is this? This is your client's case on verification, and you are proving it wrong.
That is true, my lord.
That is true. It has to be true. That is his statement on verification.
Lordship, come to the fact, my lord, for a moment.
Sorry, we are not going to reopen the entire thing.
No. Lordship, kindly see, I have annexed the application.
We will not go into it. Your application will only be in support of your statement, not divorce the statement. It is not your case. We thought so. It's nowhere to be found. This was group D. This was not for any particular post.
Yes. That is notification.
Even if it was, you have said you have not applied for any particular.
That is the wrong.
We'll record that. We'll
That's a
record that. That is as it is.
That is.
How do you know it is a mistake?
That is mistake.
As a counsel, how can you say it was a mistake? His statement on verification. He stands by it. He has not said that he has not sought amendment. He has not done anything.
There is a
Very unique.
construction of sentence. There is a mistake.
No specific post was ever mentioned by the applicant, nor any communication was made to the applicant. Both things, he says. Neither I have made any application for a particular post, nor any communication I have received on this ground. What, and how much more specific terms can he say? No question of any error. You were in the dark. You were not doing knowing anything. The facts as unfold from your OA is that you were not knowing anything.
Mentioned by the applicant.
And only after the speaking order, you have come to know what is going on. Until then, you are not knowing anything. That speaking order also you have challenged.
Yes,
This is the subsequent OA.
yes. This is the subsequent way. Now, she kindly come to page 32 for a moment. I think that is the mix. Paragraph M. Yeah. Page 102.
Specific direction. And for the 20% excess. So 100%. Already because it gets suspended for so long. Where is the High Court's order? Where is the High Court order which the tribunal has relied upon?
That is not here. My lord, may I, for my satisfaction, may I place two documents, my lord?
Yes, you may. We have gone through your entire OA. We have seen you don't know anything.
Because, my lord, they didn't, for the first time, came to learn after
Correct.
speaking order.
Which is correct. So therefore, you don't know anything. That is a fact.
Yes.
You don't know whether you were within the 100%. You don't know whether you were in the additional 20% because the panel is made in excess of 20%. But you know that you are subjected to a medical test wherein you were placed at A2 category. Now, as a result of the subsequent exercise, you have been downgraded in A3. You say A3 also, there are many posts, please give it to me. This is your prayer in the OA.
Yes.
So therefore, now you cannot get anything more than that.
Yes, yes.
So that is why they have said that you will be placed in replacement panel. What better can
Now,
you
Lordship,
get?
if you Lordship kindly go to page 144, Madam. 144.
Yes.
First paragraph, last 4 lines. Sorry, a candidate. It starts with the word candidate. First paragraph, last. A candidate should submit only one application form, even if he wishes, even if he or she intends to be considered for more than one or all categories.
This is not relevant. You never knew whether you were within the 100%.
No.
You have no basis to claim that you must be in that panel.
No.
Placed in the panel
No,
from
that
which
is not my case. I am not saying that.
this is
I am
not
saying
relevant.
that I applied. I applied for 5 posts.
We don't know.
Yes, Lordship kindly come to page 182.
Yes.
182. Lordship got it? 182?
Not required. See, your first OA was withdrawn.
Because no representation was made.
Yes. So therefore, first OA is nothing. Only after the speaking order, you have come to know of anything.
Yes.
So therefore,
No, Lordship, if you look at page 182.
first OA, you have not said anything.
Yes.
Therefore,
anyway,
see,
but I was not there. I cannot say.
No, if the facts were with the petitioner, he would surely have said whether you are there or someone else.
No,
That is
Lordship
the
kindly come to
message.
page 182 for a moment. Post applied for.
Even if you have, you were not selected. You were not offered appointment.
Offered appointment because
At least till 2017.
offered appointment
Only
because
after 17, when you took up the issue, then they have examined, they have taken a second medical and you have been downgraded. You
downgraded.
may have applied. That's not a relevant fact today.
No, downgraded because to A3 category.
A3, correct?
I applied for A3 category.
So therefore, the tribunal has said that now in the downgraded category or whichever category, they will consider by putting you in a replacement panel. You could not have got anything better according to our assessment. You can't be placed in the panel of 100% without knowing what it was, what was the last cutoff, where were you, nothing is there. How can they say that you should be put in the panel and given an appointment?
I was already in the panel.
Nobody's case you were within the 100%. We are saying repeatedly,
No,
the
speaking
panel
order,
is in excess of 20%.
speaking order does not say so.
Huh?
Speaking order.
The process that you have given us, it says so. It is presumed that it was prepared in that way. That
Yes,
circular you have given us, it says so.
Yes, but
That is why it is a provisional panel.
speaking order said that I was within the zone of consideration. That's why they offered me porter. I did not apply for.
Where does it say you are within the zone of consideration?
Yes, they offered me. They
Where
considered
do
me.
they say that you were within the zone of? Show us this line
Yes,
in the speaking order.
yes.
Yes,
Page 71, my.
yes. They don't say anything. They say, oh, the first was inoperated, not operated. Thereafter, they have considered after a lapse of so many years. Therefore, because the nature of duty which is to be assigned requires a high physical standard because public safety is involved. Therefore, we were compelled to take another medical test. In the next medical test, he has been found in A3.
Earlier he cleared. Earlier he cleared.
Earlier you were A2, now you are A3 in the medical.
Yes.
That does not mean you are within the 100% in the panel.
The panel is
The A2 qualified may be up to 120 and there may be only 100 vacancies. The circular is clear. It says merely because you have qualified, that doesn't mean anything. Ultimately, only the number of vacancies for that appointment will be done. After that, whoever remain, if there is no joining or there is a vacancy which remains, then only the
but
replacement
they
panel
said
will
that
be done.
I was considered against the post of porter. Again,
That's not relevant. That's not relevant.
my
You were
case-
considered does not mean you were within the 100%.
no,
That does not give you a right to be in the
Lordship, next
panel.
page 73.
That does not give you any right to be in a better position than a replacement panel. Your only objection is why replacement panel. There is nothing more here today.
Yes.
So why not replacement panel is the issue that you have to satisfy us. You
Lordship,
were never in any panel. So how
Lordship,
can you
see
be?
the page 73?
Yes.
The applicant is among the one of those who was declared fit in A2.
How many
Was
times you will say that, sir? Declaration of fit does not mean within 100%.
due
Sir,
to
we
this
are-
reason, he became unfit for the post.
That does not mean that you can be in a better position. Sorry, yes, take down. It's enough. Ordinance Council for the
Item number 1.
Item 1, this is my application for restoration. This was not dismissed for default, which is within time. Dismissed for default for Justice Devanshu Boshak and Justice Shabbir Rashidi on 9th of October 2023. My application is not CAN 1. My annual account record at that point of time was suffering from viral fever. Therefore, the matter was called on. He was unable to attend the.
So what is the merits of the matter? Let's see.
On
Come to the merits.
on the merits, may I indicate? This is an application for challenging an order from the West Bengal Administrative Tribunal, where it was my specific case for compassionate appointment.
So you are son or what?
I am the son.
Son, your father died in harness on?
My father died on 8th of January 2014.
As working as?
But he was working as, I'll indicate from the order itself, where he died on 8th of January 2014, and thereafter my mother made an application for compassionate appointment.
Sir, we asked you what he was working as.
Distributor grade 1.
This is in which department?
In the government press.
Distributor grade 1. So it is like some vendor.
This is a post in West Bengal government press at Coach Bihar.
All right.
Thereafter, what happened is my mother, who was being the widow, made an application.
When?
On 31st of January 2014 for compassionate appointment. In that application, she relinquished her right for compassionate appointment so that I, being the son, can.
So she made an application for you?
For me.
Yes.
Now that application, was not considered for long. For 4 years, it was not considered. I have waited for that application. Now thereafter, I approached the tribunal after 4 years. As after 4 years, I approached the tribunal. The main contention why my application was rejected is that solely on the point of limitation that I being waiting for the consideration of the application made by my mother does not satisfy to be a sufficient cause for the condemnation of delay. And on that point itself, my application before the tribunal below was rejected. That kindly comes to the order minute. I shall place the order minute at the end of the order sheet is there. May I place it, minute?
It's not clear.
My representation is at page 26. This is my representation dated 31st of January 2014. Now, at the bottom, may I place it? Amari Prappo চাকরি আমার মানে this is vernacular my lord if may I furnish a translated copy my lord I'll come back with that.
Yes.
Of any malord financial hardship for which the claim has been paid. But this compassionate appointment is not a malord way of it's a malord employee requirement of the for the financial in the application and to find the application. That is for the financial hardship we cannot sustain and hence I want the malord service.
And if she says it's for financial hardship, you will give it.
Consider that financial
So we are asking you, where is the consideration? Whether she says or not says, that hardly matters. Ultimately, your 3-member committee will examine, and the 3-member committee will examine whether if the applicant fulfills the criteria or not. That is the procedure. So therefore, what have you done? We are asking you. You have kept it pending for years together. Time is of the essence in this matter. How do you sustain? How do you support the tribunal's order? What kind of order it is this?
another thing that I told you that malord the
Consider her case.
the order itself, malord, there is no application on the part of the applicant. But I think it's the
That is not your stand. That is not, you have not filed any opposition before the tribunal. Just look at the way the tribunal, from where he has got this, tribunal has got this. So the mother's application is not sufficient. Then how is it relevant whether he has filed or not filed? The mother has relinquished her claim in his favor. You are unique grounds you are raising. Yes, come. We are remitting it to the tribunal.
My lord. Yes.
Both.
Yes.
We have seen so many cases, 7, 8,
Item number 3.
that they say that your application was barred.
My lord, I am for the petitioner, my lord. I'm filing my affidavit of service, my lord. As per Lordship's direction, I served the copy of the canned application.
Can, what is the can?
Restoration application, my lord. Which is misplaced, I think, from the record itself, my lord. The last occasion.
Dismissed on report.
Yes, dismissal, but within time I filed the restoration application. That application is not there, my lord.
What is the date of dismissal?
My lord, date of dismissal 13th January 2016, my lord. And within time filed that.
13 January.
Oh, yes, my lord.
But there are so many orders after the 13 January.
This, my lord, I filed that application and they appeared on that time, my lord. The other side.
Can 1031 is for restoration.
Yes, my lord.
So,
Yes, my lord. Copy, my lord, by hand.
there is a post senior government advocate.
There is a advocate Sunil Chakraborty was there, but I came to know that he is dead.
You have given us a copy of affidavit on service. Page 3 of the affidavit. Please see what it says.
Yes, my lord.
Who is this person? Senior advocate, senior government advocate, Ministry of Law and Justice.
So, Lord Justice, there was Sunil Chakraborty, but at present, I don't know.
No, no, you have addressed this to some senior government advocate.
Yes, my address is gone. Address is wrongly indicated. But they are aware of this case, my lord.
Received correspondent. So all these are served on the Ministry of Law and Justice here. They are not served on the councils.
Agent, they told me that they did not engage the council in this matter, my lord.
But they have
Verbally
received it. Nobody is appearing. Let them not appear. What can be?
They are aware about this case, my lord.
Hmm?
They are very much aware.
Must be. There is a receiving.
Yes.
12th March they have received
Yes,
it.
yes, 12 must be received.
You have also indicated the date of 9th.
The writ application, my lord.
What
Only-
writ application? See what you have said in your restoration para 3. You want us to certify this? Then why do you make such a statement?
No, my lord. Explains what-
Why do you make such a statement? If we accept this, we'll be certifying this. We are not going to go into this. This cannot be a ground. We don't know for what reason you are suffering, your counsel is suffering with a mental agony. Very unique. It appears that you are trying to resolve something with someone in the garb of a restoration application.
That's why actually there's a lame excuse, my lord. Actual
It's not a lame excuse, it's a aspersion on an officer, and you want us to accept this as a valid ground, and he has nothing to do with your case. A stranger to the proceedings. Why are you dragging? He is not before the court. We are not going to accept this. Sorry. We will not accept this.
actually petitioner has no personally guilty. He has no latches, but his counsel made some mistake.
Mister, please, you read what you have said in para 3. We hope that you have read it.
Yes,
How can we allow you to make such an excuse and accept it against a person who is not in the proceedings and holding such a position without hearing him, and you want us to certify all these things by accepting it as a valid ground? No. We are going to reject this. You want to file afresh, you file afresh. We don't know. We will not accept this. Yes, take them. Yes,
liberty may be given a file fresh.
yes, you should. We find
Item number 4.
you have filed Wakalatnama.
Yes, Okalama has been filed in the department.
Yes, sorry.
Yesterday,
Yes,
we are informed that wakalatnama has been filed in the
I did today. It has not yet been received. I think
not how it is.
I can supply the same in course of the.
To stop. Is there a photocopy? So we have seen. Fine.
Item number 5.
For the respondent number 1, 2, and 4.
In this matter, Mr. Gendar is appearing, my lord. He has told to kindly make it the matter, my lord, for next week, my lord, was Monday. On last occasion, lordship is directed to, my lord, in this matter, the petitioner to ascertain the respondent number 3 to the effect for effective service, my lord. My lord, though it is, my lord, the constitution has been amended, and after the death of the incumbent, my lord, this, my lord, the respondent has been added. So, my lord, we are unable to trace this respondent number 3, my lord. Kindly see the, my lord, order dated 22/2025. We have served twice, my lord, but same has been returned. Mention address he left. My lord, the family member of the incumbent, if they have know the, my lord, the address, so that, my lord, the communication be made on that address.
As played by
Yes, my lord.
what do you want the court to do?
My lord, if the registrar send a notice to the other family member to, my lord, inform that the respondent number 3 be communicated, my lord, we are unable to trace the address, my lord.
So how the registrar will send if you are unable?
My lord, the family member or the, my lord, court, if my family member produce this address, other respondent, my lord, other respondent of the, my lord.
If you take steps, you take whatever steps
Much obliged.
is open to you to file such an application. You can file it. For we said take steps. You take steps. Item number 6.
My lord, I appear on behalf of the petitioner. The issue relates to the regularization of the study leave period.
Of the
Of the study leave period, the course that the petitioner took abroad, your lordship. Your lordships have heard the matter at length. This is with regard to the course that Paramita Verma, the petitioner, undertook with Chiltern Railways, United Kingdom, your lordship. On the last occasion, my lord had asked the respondents to find out if they could consider the mitigating circumstances under which he had to finish
Do you
the.
have any
Lordship,
instruction?
the rules are annexed at page 32 onwards, Your Lordship. Rule 33 states, Rule 30, at page 33,
No, last time you said some documents were not with you, therefore you had short time.
Your Lordship.
So what is that document that now you are placing? You said that you have received instruction but not supported by documents, and therefore you sought a time. What documents you have received?
This is the entire study leave rules. Rule 2. It is annexed at page 34 also, Your Lordship. I'll rely on the documents.
But where is the instruction that you have received? We have recorded your submission that
Your Lordship, this is the written instructions, Your Lordship.
let us see what they have said.
This is instruction from the client. Instructions from the client. Under the rules, Your Lordship, even in case of any sickness, page 36, 14 days extension can only be given subject to the same being applied, and apart from the merits that
This is the leave rules.
Leave
This is the study leave.
Your Lordship, that is annexed at page 33 as well, Your
In a
Lordship.
brief.
32 onwards. (32) of the writ petition, it is annexed, Your Lordship. I was relying on page 30.
No, but you have said in your instruction is that she was required, she was asked or given an opportunity to submit application for regularization of the period, which she has not done. So if she makes an application, then what can you do?
Your Lordship, page 36, the rule says that provided the authority rule 3's proviso, sub rule 3 proviso of rule 7.
Page
Page
36.
36, Your Lordship. Sub rule 3, study allowance shall not be granted for a period during which a railway servant interrupts his course of study to suit his own convenience, provided the authority competent to grant leave or head of mission may authorize the grant of study leave for a period not exceeding 14 days at the time during such interruption, if it is due to sickness. Even due to sickness, we can grant only till 14 days, and that too an application has to be made. And your lordship, in case of
What is the excess in this case? What is the excess number of days? How many?
Lordship, may I submit? The total earned leave that she's accrued is 300 a number of days.
300.
Yes, your lordship. So as per them, 145 days are the extra days which she overstayed. So 155 remains. But
She overstayed 145 days.
as per them,
So even if it is adjusted against your earned leave, then you will still have some.
lordship, so that 300 earned leaves equal to approximately 12 lakhs, your lordship. So she'll be deprived of
Is
nearly
equal to 12?
12 lakhs once she superannuates. So if she's deprived of 155, that comes close to approximately 6 lakhs rupees. She's a single mother, your lordship. They had inquired. The application was sent through Chiltern Railways saying that due to extreme urgent circumstances, she's finishing the course early. But she did finish the course. And of course, she could not have sent the application for sickness and all because she was not in a situation to do that, your lordship. So, lordship, today my humble prayer is that she's not asking for anything extra. She's not asking to be compensated. She's asking for what she thinks is legitimately hers, your lordship. And the conduct of the respondents have not also been above board, your lordship, because there was an inquiry where they re-inquired if she has finished the course, and Chiltern Railways, by their letter again on the 24th of July 2012, had reconfirmed that she has completed the course. Yes, early, but she had completed the course, your lordship.
Your lordship, on completion of any course or certificate,
The leave was subject to certain terms and conditions explicit in the permission granted to you. You have not complied with the requisites. We were not on merits. We wanted to see, because you have raised an issue regarding some critical illness of your son, which prevented you to see whether there is any residuary provision in the rules which may be invoked in your favor. That is why we had asked them to take some instructions that having regard to this mitigating circumstance, whether they can do something. Otherwise, we have gone through it. Whatever may be the extreme circumstances, you can't do this. After all, it's public money.
Lordship, she went for the course on the
Let us
bona
see, have you
fide.
gone through the leave rules? Is there any
Lordship, I
such?
have gone, and what my learned friend is submitting is.
There is no scope in the leave.
I don't think, except for. I also went through this clause through your lordship, and
Clause 4,
clause 3, page 36, your lordship,
application.
of the study leave rules, your lordship.
No, what is, which provision of the study rules?
This is the 3 of Rule 8, your lordship. Acha. Lordship, Rule 8, which starts from page 35, bottom of page 35, your lordship.
Conditions.
Lordship,
Conditions for
grant
grant of
of study allowance. There's sub rule 3.
We were seeing 8, Rule 8.
My Lord, will kindly come to page 38.
Can you please point out the relevant rule? We have a copy
Yes.
of the rule we are referring to.
Subclause 3, Your Lordship.
14.3.
Yes. My Lord, I would stress upon the phrase to the peculiar circumstances of the case under which my petitioner is, Your Lord.
So actually, you are also alleging that she has not qualified, she has not
Submitted the
complied with
certificates.
the requirement in 4.5. 5 says on completion of course of study, the railway servant shall submit to the study leave certificate of examination, pass a special course study undertaking. So all these she has not complied.
Lordship, she is not submitted at page, she's not submitted any certificate for after completing any course, a certificate is issued.
Therefore, we said just see Rule 4.5.
Your Lordship, Rule 4.5b is more applicable if the study is undertaken in a country outside India.
So it is part of 5,
Your Lordship,
sub Rule 5.
where there is an Indian mission, the certificate shall be submitted through the head of mission concerned. That has also not been done, Your
No,
Lordship.
but then therefore we had asked you to see this in Rule 14, sub Rule 3.
Lordship, Rule 14 deals with resignation, retirement in case if during the course or after the course, in spite of signing the bond, and that can be done by the president.
Yeah, that is retirement resignation, but to see the note below 3, what does it say? So for 4.5 also, a consideration can be accorded.
Lordship.
Whether it will be granted or not, we don't know. That is why, because she is raising some mitigating circumstances. Whether it can be considered or not, it's not for the court to say that it must be done in that way.
Lordship, but Rule 14 deals with resignation and or retirement.
Therefore, we are saying read the note below.
The amount referred in sub-rule 1 of the aforesaid Rule 14
Yes.
shall
Also be refundable.
by the railway servant. We have not asked till now for refund, Your Lordship.
No, but ultimately it will amount to a refund.
Who fails to complete the course of study and is thus unable to furnish the certificate as required under sub-rule 4 of Rule 4.
By a railway servant. Nothing. And there is no exception to this rule.
Lordship, there are no exceptions.
Then why does your instruction say that she can apply for regularization of the period of absence?
Lordship, page 58 is our letter, which is 5th of May 2011, wherein also we had stated that third paragraph. For extension of study leave beyond 1 year, no request has been received from either Miss Srimati Verma nor from the Railway London. Her overstay period beyond sanctioned study leave on and from 1st October 2010 to 25th February 2011, that is 4 months 25 days, has not been sanctioned as foreign study leave within the leave of the Railway Board. There is little scope to obtain sanction of such period from Railway Board. As such, she may be advised to submit an application for regularization of her period of absence beyond foreign study leave, either in granting LAP or from LHAP. LAP is, Your Lordship, leave not due. LHAP is leave, extraordinary leave, where when she has 60 days LAP as on 2011 and 90 days LHAP due to her credit as on that date. For that purpose, we had asked that she may apply for regularization and that amount may be considered from, that is also subject to.
Page 58 is page 71. There are two page numberings. We don't know which
Page
page.
58, 5th of May 2011 letter, Your Lordship. Your Lordship, the writ petition, not the supplementary affidavit, Your Lordship.
Writ petition.
Writ petition, Your Lordship. A7 annexure.
What is LAP?
LAP is leave not due. Leave on average pay. And LHAP is leave on half average pay.
So did you apply for this?
Because she did not, because she thought it was unfair on the part of the respondents to ask for that. When Lordship, may I submit here that she was paid the stipend, which is the amount for the study leave for the 4 months that she was there abroad. So she was under a bona fide belief that she has been sanctioned the second year of Lordship, at the cost of repetition, Your Lordship, may I kindly ask Your Lordship to come to page 42 once more, Your Lordship.
42 of supplementary or writ?
No, Lordship, the writ petition.
We have examined everything.
Lordship, for my satisfaction, Your
Yes.
Lordship, the handwritten, may I read it
No,
once again?
this file noting we are not going to rely. That cannot be relied upon to ascertain the rights of any individual. Unless the notings in the file culminate in an issuance of an order, the law is well settled. It cannot be relied upon. It is a process of consideration, not a crystallization of the consideration. Therefore, it cannot be relied upon. Whatever has finally been, there may be many things proposed in the file. It is what ultimately is contained in the order that is to be seen, not the file. It's a well settled law by now. And therefore, we have refused to look into it. We don't want to, and we will not look into it.
Lordship, the petitioner is retiring in the year 2027. She's a single mother. She'll be deprived of approximately
No,
6 lakhs.
that is, you have already submitted. Therefore, we were asking you, if you are not desirous of availing this opportunity, then we'll pass the order.
Lordship, I'll take instructions, Your Lordship.
Come back quick.
Yes,
We have heard it.
Lordship, I'll come back tomorrow.
The learned counsel for the Item number 7. But it's
দাঁড়া দাঁড়া আলাদা রাখ এখন আলাদা রাখ একটা একটু করে দেবো
yes.
Lord, I may be excused, my lord. First of all, my lord, yesterday, my lord, I was engaged in another court. My
You were excused yesterday. Now that is over. What was yesterday is over. Yes.
lord, your lordship may remember is that case. Your
Yes,
lordship
we
was asked
very
my
well remember. We asked you whether
Yes,
it is
yes.
open to you as a state within the meaning of Article 12
my
to
lord.
take a different stand with respect to two people
My lord.
when the Supreme Court has said that all those in the list are to be accorded this
My
relief.
lord, this is my submission here. They are not in the list.
Or let us see. Where is that list?
My lord. That's why, my lord, if your lordship kindly see, my lord, my list of documents I have prepared.
No,
Because-
no. Nothing beyond the record.
No,
Nothing
the-
beyond the record.
My lord, if your lordship kindly
Sorry.
see the order, all these judgments and my lord, it's
No,
not,
nothing beyond the
no,
record.
no, judgment, my lord, judgment is not annexed here, my lord. Kindly see
Judgment
the,
is not required. Where is which is the list which has been referred to? Let us see.
my lord, kindly see, my lord, the order of the Honorable Supreme Court first. That is, my lord, S.K. Murthy, my lord.
What is the date of the list? Where is the list?
My lord, I am coming, my lord. But may I read, my lord, the relevant portion which my learned friend is referring
Of?
of, my lord, that judgment which is, my lord, traveling us, my lord, that the persons, those who have not approached, even then they are entitled. This is their main ground, my lord. So if your lordship kindly see, my lord, the order, my lord, kindly allow me to, my lord, place the order, my lord. Because order is not annexed, my lord. May I, my lord, hand over, my lord?
Order is annexed, page 57.
No, we order na.
Page?
Or no, my lord, order of the Supreme Court, my lord.
Now, my learned friend, just now you submitting before the lordship, our clients are not in the list. Kindly come to page 57.
No, list of the judgment passed by the Honorable Supreme Court. Supreme Court has referred the list in respect of the another matter, not in this matter. This matter filed in 2014 and the judgment of 2011. How it could be, my lord?
The promotional list, my lord.
My lord, may
Where
I?
is the promotional list?
Yes,
Come to
that
the
is
promotional
My lord.
list.
Page 57.
Page?
57. Oh,
Page 76, kindly come.
76. Yes. Sorry, other cutting here. All the respondent names are there, my lord. Starting from 6. Miss Dr. A.K. Sanewal.
AK Sanal is there, but SK Murthy is not there. SK Murthy judgment of prior to this. SK Murthy of 2011. This list of 2014. This judgment has similarly circumstances. That is the different issue. That I will argue before your lordships.
So this Dr. S.Z. Siddiqui or Murthy is not in this list.
No, my lord.
Siddiqui is there.
Siddiqui is there, not Murthy.
number
Murthy is
38.
judgment of the Supreme Court. Siddiqui is judgment of Tribunal and High Court.
Siddiqui case, my lord, the Central Tribunal, Hyderabad. Mein
My
just
lord,
passed this order.
my lord, that's why, my lord, may I allow me to, my lord, place the judgment sequence wise, my lord, from the record. No, Joyce बोले तो.
So Siddiqui has been granted by you?
Yes.
Siddiqui has been granted in view of the order passed by the Tribunal and High Court. But Siddiqui was immediately approached the High Court, Tribunal and High Court.
What is the date of Siddiqui's judgment?
My lord.
I am giving it.
High
And they
Court?
are fence sitter, they are not be entitled to get that benefit.
Yes, same.
SK Murthy, Binoy Kumar. It is already referred in the, my lord, impugn order, my lord.
My lord, Siddiqui case has been decided by the Central Tribunal Hyderabad bench on 24/7/2015.
15. This is immediately he.
Thereafter, my lord,
Sir, may I please?
How are you making submissions?
but they did not disclose this
No,
document.
I am disclosing. May I
When
read?
they are complete, you tell us what they are suppressing.
Yes, my lord.
If they are suppressing, you tell us what they are
Yes, yes.
suppressing after they complete.
My lord.
After every submission, you will make a submission.
But may I read, my lord, the impugn order, my lord? Entire thing will be clear, my lord. May I read, my lord?
No, just give us.
My lord. Page 85, my lord. First of all, my lord, they have not challenged the withdrawal decision of the, my lord, department. They have, my lord, filed the original application before the tribunal for implementation of the order passed by the department for granting the retrospective promotion. But the decision taken by the department for withdrawal of that, my lord, promotional list has not been challenged.
Now, where is the Supreme Court order?
My lord. Supreme Court order, my lord. There, compilation there. এই compilation দুটো দিন না, my lord, আরেকটা compilation দে।
He don't give us 10 judgments.
My lord.
Just give us the Supreme Court judgment.
Well, I have annexed, my lord, with
We
stitching.
are not
No,
going to take
I will refer from this, my lord, document, my lord.
just the Supreme Court judgment.
Yes, I am
Don't
referring to.
push documents to us which are not on record.
No.
We are not going to take.
I am only, my lord, folding that.
Only Supreme Court
My
judgment.
lord. 30.
Only.
List only and for the different.
So it must have said that it only for this list.
Yes, my lord.
Where is that shows from the judgment? Where it
Well,
says
can
only for this list, where this expression has been used?
page 30 kindly see.
Yes. Where does it say from this list only?
Well,
Shows.
I'm giving. নাম দিলাম তো ও পেজ নাম্বার নাই page 30 my lord kindly see page last paragraph of this my lord page I have folded my lord. Since the time fixed by the High Court for compliance of the direction given by it has already been expired, we direct the petitioner to do the needful within 4 weeks from date. Thereafter, kindly come, my lord. Similar orders shall be passed for the all other similarly situated persons, despite the fact they have not have approached the High Court questioning the order passed by the tribunal. This direction is being given to avoid further litigation in the matter.
So where is the expression from this list, same list?
Well, this is a matter of 2011. Here, my lord, subsequently this list has been published. So this cannot be the same. And I will show to your lordship the list.
So for Siddiqui, it can be the same. For them, it
Siddiqui
cannot.
same, my lord. Siddiqui same.
For them, it cannot be the same.
No, for that is different department, different issue, and my lord, the different, my lord.
Siddiqui is in a different department from these persons.
Siddiqui is different department, my lord.
From these persons.
Yes, yes, my lord.
He is in the same list.
Siddiqui and our case in the same list.
Then why are you saying such different department?
No, this matter, my lord.
We are asking you if Siddiqui is similarly situated for the purpose of Supreme Court judgment, and he is in the list which the petitioners are.
No, my lord. My lord, may I clarify?
No, you may not. First you listen, then you clarify.
My lord.
We are asking you if Siddiqui's case is similarly situated as these petitioners before the Supreme Court, and Siddiqui is in the same list as today's petitioners, then where is the distinction?
No, Siddiqui's judgment, my lord, matter is related to us in the same list.
Yes, and you have found him, you have held or you have accepted him to be similarly situated as the judgment of petitioners, respondents before the Supreme
No,
Court.
my lord.
No, you have not implemented in his favor.
No, Siddiqui, our list, this.
Where is the judgment passed in Siddiqui's case? Show us. Please remember too that we have passed an order 2 dates earlier, that it may entail consequences. We are keeping that issue open in our mind. It may entail consequences.
My lord, kindly allow me, my lord, to place our
Yes.
case.
Where is the Siddiqui
My lord,
judgment?
Siddiqui is the tribunal order, my lord, is not with me, my lord, here.
Show us.
Siddiqui's judgment is not here.
You are trying to draw a distinction between Siddiqui and these persons.
Siddiqui and these persons are similar.
Then
But Siddiqui and the judgment passed by the Honorable Supreme Court is not similar.
so therefore, how he has been granted, that is why we want to see.
Siddiqui was, my lord, initially approached by the before the tribunal.
Siddiqui
And here
has
after
been granted considering the Supreme Court judgment or not. Let us see.
my lord, Siddiqui's judgment is not, my lord.
Give it. We want you to bring it.
Siddiqui's
We will
judgment,
direct you to bring it.
Siddiqui's judgment.
We will direct you to. You must get it.
I am giving the
order.
You must get it. What you are trying to do, we must ascertain. What you are trying to do, we must ascertain
The cat order, High Court.
whether you should be approaching the litigation in this way. That we will consider in this case.
They
Be
implement
very
my order.
conscious. Yes. No, give us 2 copies, not like this. Give us 2 copies.
And my lord, thing is this, my lord.
Till after Siddiqui's judgment, show the judgment, then we'll hear you.
আমার ক্যাটের 64 পেজে আছে ক্যাটের পিটিশনটা এনক্লোজ করে
No, just we want to see Siddiqui. He is saying Siddiqui is to be treated differently from these
are
persons.
in the same list.
So
Siddiqui is
whether
the same list.
Siddiqui,
Siddiqui is in the same list.
you think we have any doubt on this?
No. But my lord,
Why are you saying that?
well, Siddiqui approached the tribunal immediately.
Immediately.
Here they have.
Therefore, he was to be extended the benefit of Supreme Court judgment.
Yes. No.
So let us see.
And here, my lord, they have
Sir,
approached.
the issue is whether they have been granted the benefit of Supreme Court judgment. Anyone from this list, if he has been granted the benefit of Supreme Court judgment, can you deny it to someone else?
Because of the delay, I can
All
deny.
right. Then let us see what
My
is
lord.
the judgment, the Supreme Court judgment.
My lord.
What has been decided in Siddiqui's case. Let us see.
The 2 copies, mother. Tribunal.
No, give us 2 copies. Don't give us.
2 copies. 64.
Yes, where is it? Read Siddiqui's judgment.
Mukhtarmନ୍ତ୍ରୀ chairman have been relied upon. by the tribunal.
Category কই?
টাকা দেয়নি আপনার
আরে কি করবো আমি ফাইল করেছি আমি আলটিমেট
paragraph 7.
Yes.
Now the Siddiqui's judgment,
All right. Now you may make whatever submission.
my lord.
You
Now-
give us a written submission, we'll consider.
Well, kindly allow me, my lord, to place, my lord, the 2-3 judgment, my lord, only, my lord.
What judgment?
That even if the
Yes.
person situated in the similar circumstances, if they are fence sitter, they are not entitled for the
We
benefit.
are not on that issue. We are on the issue whether when the Supreme Court says others similarly situated and one person from that list you consider to be similarly situated, whether the others are to be considered otherwise or not.
My lord, the similarly situated,
This is the query of the court.
my lord,
You may make whatever submission you want,
my lord.
but this is what you have to satisfy us on. Being a state within the meaning of Article 12, when you accept the finding that one person from the list is similarly situated for being extended the benefit of Murthy's case,
My lord.
then the other how you can discriminate.
Now,
That
my
is
lord,
the issue.
my lord, here,
Because
even-
he has come later. That is your answer. All right. So you say they are
8
fence
years,
sitter.
fence sitter, 8 years.
Give us
No,
the written
my lord.
submission.
The judgment will be-
Siddiqui's judgment is of 2015. What is the date of his judgment?
And Siddiqui approached, my lord, in 2012.
12.
12. And here they have approached 2022.
Siddiqui approached in 12, but the promotional list is of 14.
14. That this is, my lord.
How he could approach in 12 when the
this-
promotional list is
I
of
don't know, my lord. This is I find from, my lord. This is from the another, my lord. This is not from Kolkata. This is from another, my lord, state.
But the promotional list is of 14.
14.
Then how he could approach in 12?
12. Kindly see, my lord. This is the order of.
Before the promotional list he has approached.
Yes. I don't know, my lord, because this is from Hyderabad bench, not from Kolkata bench.
How it can be, sir?
Come to page 57 of their writ petition.
What is the date of the promotional list?
Yes. That is page number 57.
Okay, sir.
76.
14, then how the
14.
OA has been filed in 12?
And Siddiqui name is, they are in the said promotional list as serial number 38, page 77.
When we ask you to clarify something, you repeat something which we have said.
Then
where is that? Internal page 2 of the OA judgment. Siddiqui's judgment, we have it. 72.
From the post of scientist to scientist B, take from the post of scientist. About the case conducting the by the respondents, the applicant's case was considered for promotion from the C to B with effect from 2008. Other they had not been taken up for consideration at all by the respondent. In the applicant declared from submission.
And our case is, my lord, further action from 14.
Was delayed by about 2 years. The promotion for the court of scientists is that delayed for witness 2010 and not accounting
on account of delayed convening of the selection committee meeting. This act of respondents has not the applicant on promotional opportunity is also contended by the applicant that he did not suffer for the delay caused in conducting the interview on due date. It cannot be deprived of the date on which it falls due and the delay is applicable to the respondent of it. Then what is the respondent please then escape is denied as in escape as decided in escape.
No, but if we are on this, that if you are in a common promotional list with Mr. Siddiqui and Siddiqui has approached the tribunal getting a relief by virtue of his position in that list, how he could have approached the tribunal 2 years before the promotional list came into existence? How he could have approached the tribunal 2 years prior to coming into existence of the promotional list?
The relief given by this tribunal was in relation to a 2014 process, not for Siddiqui. He entered in 2012 and he said that his grant to promotion from 2018.
But his name is in the same promotional list. 2014 promotional list. The next page, we have just seen it. The next page, second page.
In pursuance of the Ministry of Environment and Forest of 2013 and subsequent data dated 30th approval for production of publicity promotion of the scientists under flexibility from their new states from 1999 the principles considering all those questions.
Please clarify what we are asking you. We are not asking you the merits of the claim. You are claiming parity with Siddiqui. You say you are in the same promotional list as Siddiqui. Siddiqui and you are in a promotional list which has come into existence in 14. How he has approached the tribunal 2 years prior to coming into force of the... Yes. Yes.
Tribunal said you in this particular matter. So the ministry was directed to act. This action was taken by the ministry in 20, considering all cases from 1999. That's why Siddiqui which are in the same.
Oh, so this was as a result of the order passed by the tribunal. At the time of passing of the order, this list was not in existence.
Order was not.
So then it must be manifest from the list that this tribunal's order was taken note of. Let us see where that list is.
That is from the certificate of the recognition. Environment and subsequent data of 30 days 2014. Consequently, thereby approval for Calcutta Geological Survey of India under flexible complements from 1/1/1999 onwards.
But this is not in compliance of the tribunal's order. It is not in see, unless a link can be established with the tribunal's order and this list, then you are claiming parity with Siddiqui, then they may have a case to argue.
All the persons alike.
That is all right, but that you say it is because you and them both figured in the same list. But you were not in the same list when the order was passed by the tribunal. Then
I came to place that.
And I came parity in respect of all those persons who have to be treated alike by the
then it is not a question of two persons being in the same list.
2014.
Correct.
The Siddiqui's name was not featuring in any other list.
No, but this order, this promotional order does not manifest that it is in compliance of the order passed by the tribunal.
But why is the expression said from 1999 onwards, all those who were similarly situated had been considered.
So therefore, they are taking the ground of fence sitters.
Yes.
Huh? No, no, but the tribunal has proceeded presuming that because you and Siddiqui are on the same list, therefore they cannot discriminate. But this is not a fact. The order passed in Siddiqui's case was even prior to coming into existence of the list. This does not manifest from the tribunal's consideration. Of the tribunal's order. No, no, no. In your case, the tribunal has proceeded on the consideration that since you and Siddiqui are in the same list and the benefit has extended to Siddiqui, therefore why not you? That is not a correct consideration on facts. The facts are totally different. The facts are that Siddiqui has invoked the tribunal's jurisdiction in 12. Subsequent thereto, the benefit has been granted to him and his name has been published in the list. Along with this petition. Yes. So to that extent, there is the fact is incorrect. Can you show from the tribunal's order that it has considered this aspect? Yes.
Page 89, paragraph 6.1.
Paragraph 4.1. During our Learned counsel from the applicant brought to our notice the order passed by the Hyderabad bench of Tribunal in November 12. In the case of Dr. Siddiqui, name appeared in the section order at serial number 38. Writing the tribunal by considering the judgment of the order.
Which paragraph? So this is not a correct state of affairs. To that extent, he is correct. Whether that goes in his favor or not, that is a different thing. But to that extent, he is correct.
Tribunal to implement the promotion order. Nothing.
And you have approached the tribunal in 22. Implementation of
2014 order. 8 years.
and in your opposition, your reply before the tribunal, where have you taken this ground? Show us. Where is the reply? (161). Why it is not part of the record? Why you have not annexed your reply?
I have asked them, my lord, there it is not due to change of panel, my lord, the documents are not. My lord, this is a practical thing, my lord, I am telling you. I may be, my lord, handicapped because there is a change of panel after 2014 and the matter of before.
Therefore, you will file it whatever way you feel like.
You-
This is a ground to substantiate or sustain your lapse. That
No,
panel has changed.
our fault, my lord.
It is your fault.
Yes.
Why are you raising these unnecessary pleas that panel has changed? All the records are destroyed in the organization. There's nothing there.
No, reply is not, my lord, traceable from them, my lord, their office. It's a
They have
fact.
said so. Show me. Show
No,
us where they have
No,
said.
during conference, my lord, I have asked them, my lord.
You are just saying anything off the cuff.
No,
We
no,
don't like such submissions. Off the cuff submissions.
This is a fact, my lord.
It's not a fact.
My lord,
It is not a fact unless it is so stated. Don't make such submission. We don't appreciate such submissions.
Sorry, my lord.
That any query of the court you will meet
No,
from
so
your
sorry.
own mind immediately
No, my lord. Sorry.
without any instructions on facts also.
Sorry, my lord.
This is not the way.
Sorry, my lord.
You place the reply on record. Take down. Learned counsel for the respondent railway. Every day we are finding writ petitions filed by Union of India not in order.
And our
At
original,
least you as counsels, Appendix 4 on the appellate side rules contains the entire procedure for filing a writ petition. Where is the paper book that you have filed?
No, paper book, my lord, direction has to be given, my lord.
Direction has to be given.
In a paper book, in our
Have you read Appendix 4?
practice, my
Have
lord,
you read Appendix 4?
and my lord, writ application usually, my lord, in appeal we
We
file.
are asking you, have you read Appendix 4? You would not have made this submission had you read it. Just imagine the difficulty we face
No,
fetching these documents. There are 3 page numbers on every document. You say some page, he says some page, and we take half an hour just to locate the documents.
My lord, it's true, my lord.
Be kind to the court. This is not the way.
My lord.
our original application also not on the record. My lord.
Nothing. That's why we are saying.
Yes, ma'am.
And then submissions in air without any pleading that a record is traceless. Why should you do this? You are not here to say whatever is required to be said in favor of your client. You are here.
My lord. না আমাকে করতে হবে ইয়েস আমাকে করতে হবে ভালো রিট করে এই রিটটা ম্যানেজ করে দেওয়ার সঙ্গে পরের দিন যাবার পরের দিন বলে রিটটা দেবেন কেন
What is the next date of this matter?
Item number 8.
Or 8, I am for the respondent in this matter. Well, yesterday matter was harder laid by your lordships regarding the wartime balance in the whole period matter. Now, tribunal has passed this order for consideration of my case. Yesterday I made a phone call 3 times to my landed friend. That matter has been called on. They are dragging in this matter.
Who is responsible?
Tribunal has directed to consider my case in view of the. Can it be? Can it be fixed on 27th? Because another matter is there.
None appears for the petitioner.
Item number 9.
No, I beg to appear on behalf of the respondent.
Matter I am from the petitioner, bring to it time, Lord, because of that, Lord.
Kindly see the order. How many times he has
Seriously,
taken?
my ill, my lord. And doctor advised to take 15 days rest, my lord.
Okay.
Parthapratim,
Okay.
Mukhopadhyay, petitioner advocate. Petitioner advocate, my lord.
Hmm.
Yes, my lord, he took time the similar PR, my lord. But doctor advised him to take 15 days time for rest, my lord.
When initially time was paid for
My lord, make it last chance, my lord.
senior.
No, my
We have
lord.
already recorded that it is by way of last indulgence. Where is the question of second last indulgence?
I am not in this matter, my lord.
Sorry, we can't do anything. We have already given a last indulgence. It has to be dismissed. Nothing can be done.
Make it last chance, my lord. I am not in this matter, my lord.
We don't know, then don't come, sir.
But-
Don't come. We can,
Mark,
sorry.
Ma'am,
See, there is no order, there is no petition or application for recall of the order. We have already directed last indulgence. We are helpless. We can't do anything. Please try to understand. We will record that none appears. Or if you want to assist us, we can just not pass any order. Not today, it will come tomorrow. If we are required to pass that order, we have to go by the order itself. You tell us what you want.
at least not 2 days time, my lord.
No, we are telling you again. We will not say a third time. Not today, we can do it.
Not today, my lord. I will inform, my lord.
Not
He will
today.
take an alternative arrangement. Alternative arrangement. If he do not come, my lord, similar.
Next, call the next.
Some other similar prayer, my lord.
Both matters not today. No order.
9 and 10, similar, my lord, advocate, similar. I will inform, my lord. Senior আছে আছে পার্থ আছে কি আছে পার্থবর্তী মুখোপাধ্যায় অ্যাডভোকেট
Number 11.
লর্ডশিপ
Number 11, my lord, I am appearing for the petition. I am filing the replies, evident reply.
Pratim Roy is appearing.
Side has served, my lord.
Reply to the opposition you have filed.
Yes,
This is the reply. You
Yes.
have served.
I have served, my lord. On 11th, I served. On 11th March, my lord.
What is the issue?
My lord, issue is, my lord, the petitioners, 3 petitioners are the ticket checking collector, train ticket checking collector. They are on duty from Katia to Siliguri and Siliguri to Katihar. Specific train. Roster point was there. What happened, my lord? When the train was approaching Siliguri station, 6 kilometers before, one TT was seriously ill. He was taken to hospital, and thereafter all the TTs came to Siliguri. In the meantime, a vigilance preventive check has been checked, found absent. They only made an absent in the relevant register, but they are not restrained to perform duty, my lord. What happened? Not restrained to further perform duty, my lord.
No, if they are not there, how will they perform
Then
the duty?
That on that occasion also, only Siliguri station they was not found, but their duty from Siliguri to Katia are not cancelled. And they, what happened? The 3 TT returned back with the next their scheduled duty. The scheduled duty was not cancelled, and that is the point. They were made absent all along for 8 months. 8 months they were not allowed to attend office, my lord. That is established, my lord. That they have also admitted fact, my lord. And what happened, my lord? We approached the tribunal first. Personal department interfered. Asked the
No, we have not understood the charge yet. They were coming in the train as ticket checkers from Katia to Siliguri.
Lordship.
Just before Siliguri, one of them was sick.
Yes.
So how many TTs were there?
3.
3. So all 3 they went to Siliguri for seeing his treatment.
No, where they brought down, my lord. They in a hospital. One TT was sick. That's why all 3 was gone there. And at the Siliguri
Correct.
station.
So all 3 of them they went to the hospital where he is.
Yes, my lord.
Then what happened at Siliguri?
At Siliguri,
Vigilance
preventive
inspection was done, or
inspection done. They found absent.
they found all 3 absent.
Absent.
Then
They
what?
made a note of it, but no further no further proceedings has been dropped.
Yes.
And they are not prevented to perform further duties more from Siliguri to Katihar.
Oh, the return journey, they were not prevented from undertaking.
Lordship.
How they can be? They were not there. They don't know. Behind their back, the vigilance came. They have done the inquiry and they have made a note that all are absent. And then they have gone. So they returned by the train.
Lordship. They perform duty, my lord.
Then-
What happened when they returned to Katihar?
Yes.
The commercial department not entered their office. No duty was allotted to him.
So after returning, they were not allocated any duty.
Duty that is established for fact, my lord.
All right.
And no salary was released, my lord. That is
What is the date on which they were absent?
Lordship. On 26th February 23, they were absent, my lord.
On 27th, they returned.
27th, they
So
returned.
from 27th, they have not been allowed to perform their duties
Yes, yes, my lord.
till which date?
They were not 4th October 2023, my lord.
And after that, they have been allowed to
No,
perform.
there is some, we approach immediately. Before that, your lordship kindly come to page 28, once it. The personal department is later, my lord. A communication to the commercial department. It will clear everything, my lord.
That is all right. We are asking you what happened after 4th October 2023.
My lord, on the order of the learned tribunal, we are allowed to.
Tribunal? When did you go to the tribunal?
Tribunal, we go to tribunal immediately.
Immediately after you were not allowed to join, you went to the tribunal.
Yes. What happened, my lord? After receiving this letter from the personal department, they initiated they transferred us inter-department transfer, administrative transfer, and no salary was released, my lord. We were before the tribunal challenging the transfer order first, and second for release of these salaries, my lord. And there was a.
We are asking you, give us the facts first. So after 27/2, you approach the tribunal.
Lordship.
Then they issued the transfer order.
The transfer order.
What is the date of the transfer order?
Transfer order is, my lord, 78, page 72. First May 2023. Page 72, my lord.
Where is the reasoned order?
Reasoned order.
মামলা শুরু হয়ে গেছে পুরো নিচে গেছিল
We have challenged the reasoned order. Where is the reasoned order?
That's It's page 73, my lord. Page 73.
Yes, we have just seen it. So this was challenged before the tribunal.
Yes, my lord.
We'll see. What has the tribunal done?
My lord, tribunal ordered that entire the opposing the preventing the duty of the TT is very bad, and they differentiate the entire period, transfer order and release of the transfer order, and they paid salary 2.5 months, about 3 months, and rest period they made disentitled us. The tribunal made disentitled us to give salary. That is why we agreed.
For, for some period, the payment has been made.
Yes, yes.
And what about the balance period?
Balance period, they tribunal treated this period as not entitlement. That we are not joined by transfer place.
Through
of
the
post.
proper channel. Or the transferred place.
Yes, yes. What happened was that tribunal ordered for rejoining my our old postings, and that's why we are.
Yes, there was an interim order of stay.
Yes, yes. Man, they didn't.
That we have seen. We'll come back.
Yes.
Only one thing,
Minute before challenging the reason order, we made a mistake. We came to High Court, my lord, filed a WPCT 139 of 2023, which is order is at page 27, my lord, which has been withdrawn. And approach to tribunal, my lord. Tribunal application.
So there are two applications before the tribunal.
Lordship? No,
Only one.
only one. We approached the Honorable High Court wrongly, and that was withdrawn and granted leave to file before the tribunal.
No, you said that after you were prevented from joining, you approached the tribunal.
Yes, yes.
When did you file your OA before the tribunal? What is the date? What is the OA number?
In this proceeding, Melo, these proceedings.
What do you mean this proceeding?
OA number
You have just a minute. You have told us 26. You went on the train from Katia to Siliguri.
Lordship.
Before Siliguri, one of you was ill.
Lordship.
All went to attend him at the nursing home or hospital where he was. In Siliguri, a vigilance raid was conducted. All of you were found to be absent.
Lordship.
Next day, you returned by the same train. You were not allowed to join.
Lordship.
And your salary was also not being paid. Then you approach the tribunal.
Lordship.
So what is the OA number?
There are two sets of petition before the tribunal. One challenging the transfer order. A transfer order was issued, transferring us from Katihat to Malda and other places.
You said that when you were not allowed to join, you approached the tribunal.
Yes, yes.
So
Yes.
where is that OA? Why are you going to transfer order? Transfer order has come later.
Until we had transfer order is made, we not approach the tribunal alleging for joining my duties, my lord. We were before the tribunal on two times. One challenging the order of transfer and other non-payment of salary on two occasions, my lord.
So you did not approach the tribunal when you were not allowed to join.
No, my lord. This is the fact.
Then why are you saying yes? You are saying yes and then you are saying no. Just let us read the order.
Lordship.
Just wait.
Yes, lordship.
Disciplinary proceeding was also started.
Yes, yes.
That you are not telling us.
Chart is at page 60, my lord. 60, 61, 62, my lord. And disciplinary proceeding imputation is that
What is the OA number which you have filed against the transfer order?
606.
OA number 606.
606. Three OA was filed on behalf of the three petitioners, 606, 607, and 605. Sorry, 605 to 607. Three OA. Challenging the transfer order.
Where is the order passed in this case?
Your lordship finds the order at page 48. Page 48. A conditional order has been passed.
Page 48.
48. Relevant order is at 51, my lord, last page, last paragraph. Paragraph 6, my lord. May I submit, my lord?
Yes.
My lord, I beg apology, my lord. I have wrongly submitted. Another 3 sets of way application has been filed, paying for release of salary and challenging our not consideration of our representation for joining duty. I have wrongly stated before your lordship. I made it maybe
There are 2 ways.
2 ways.
Yes.
And that order is as page your lordship finds page 39.
Which order?
3 orders, my lord. 670 to 672.
No, that we have seen already.
Lordship.
That we have seen already.
Oh, lordship. And that has culminated to this.
You have sought liberty to withdraw it. You did not press that application.
Lordship.
You wanted liberty to prefer a detailed comprehensive representation. In
Correct,
that
correct.
Yes. And thereafter, the only thing is that there was no stay between May to October. So in that period, the tribunal has not found you entitled for salary. That is all.
Lordship.
What can be done? Why have you not joined between that period?
But there is a stay order for transfer.
Stay in October, sir.
No, my lord. In the earlier on first May it was order.
Where is that? Show us.
At page 48, my lord. Conditional stay, my lord. 48.
No, that is if not relieved.
Yeah, we are not relieved, my lord. Not officially relieved. Kindly submit.
That is no order.
There is no relinquishment of charge, my lord. We are not allowed to join. And we are not relinquished according to joining CCA joining rules.
Where is the relieving?
Lordship kindly appreciate. If your lordship kindly comes to page 51 once.
51.
Page 5. This is the operational portion of the order. In this order, my lord, the learned tribunal has disposed of the application by directing.
Yes.
That if no relieving order has been passed as on date, but the relieving order was passed on 9th of May.
We have just observed this. Why are you repeating? Therefore, we are asking you, where is the relieving order?
The relieving order, your lordship will get the relieving order reference at the impugned order passed by the learned tribunal at internal page 9. Para 5.5.
9523.
Para 5.5, last 3 lines.
9523. Where is the order?
Order we do not have, right? If your lordship so directs, we will find
I
it.
have the order, my lord. I mean, just kindly give me 2 minutes. My lord, page 115, my lord. 115. 115, 116, 116. Relieving order. May I read, my lord?
Just let us see. Yes, all are 95923.
My lord, it is a verbal order. from competent authority. That was in the railways, there is specific order.
Anyway, if you have
verbal
not
order,
complied, you have to suffer. There is no way you can get anything for this.
my lord, it is a verbal order, my lord.
No, it is not. It is a written order. It is recording a verbal direction.
Verbal.
Now
But
the
it is not confirmed, my lord.
we don't know. That relieving order is issued. You have to suffer.
In my reply,
You are a government servant, sir.
lordship.
You can't do this. You can't be absent for months together and they say that give me salary.
But we are opposed to join, my lord. Prevented from join. There is
All
a
right.
record. Tribunal finds that. Even their reply
The
carries that.
tribunal has, in fact, given you quite a good relief. In the circumstance, the way you have conducted yourself,
Lordship.
good relief has been granted to you.
That's it. Kindly once come to their opposition at page 7.
Yes.
Paragraph 10. Paragraph 10.
Page 7, paragraph 10.
Page 7, paragraph 10. Their opposition, my lord. The respondent opposition.
Nothing. Yes.
My lord, I am placing before this honorable court Railway Service Conduct Rules 1966, which says.
Just now you ask us to read paragraph 10 and now you are. What kind of assistance you are giving?
I'm sorry,
You just now asked us to read paragraph 10 at page 7 and now you are referring to some rule. What is this?
Here it is stated that with reference to the statement made in paragraph 6 of the.
Yes, they have said you are absent. Once you are absent, you have to come and join the duty. You can't go directly and ask the person to assign your work. You have not joined. That is what they have said. That is not relevant.
Miller,
that is not relevant now. That period is not relevant. That period is over.
I am only.
We are on 9/5/23 till October only. That is all.
Yes.
Yes.
Railway Service Contract Rules.
What rules? For what?
It says, it is the oral order that to be confirmed.
Right, you get it set aside. Who is stopping you?
The railway servant who has received oral direction from the officials.
It is not oral, sir. It is in writing. It is right here. This is a written order.
But that is not confirmed later, my lord.
This is a written order. This is a written order.
Written by the inspector, my lord.
Sorry.
Same rank, holding the same rank, my lord.
Nothing can The 12, my lord, I am appearing for the writ petition of State of West Bengal, my lord. May I just recapitulate, my lord,
Yes,
the facts
please.
of the case? My lord, I have challenged an order dated 4th of April 2024, my lord, passed by the West Bengal Administrative Tribunal, whereby, my lord, the charge sheet issued in connection with a disciplinary proceeding was quashed on the ground that the petitioner were acquitted, my lord, in connection with a criminal case. Now, my lord, the facts of the case is this, that the petitioner is a constable in excise department. Now, my lord, there was an allegation that they recovered, there are other officers also, recovered 200 kgs of ganja. Now, they, my lord, in the seizure list, my lord, had shown that only 20 kgs of ganja was recovered, and the balance, my lord, balance ganja, allegedly, my lord, it was sold out to undisclosed
Allegation
person.
is 200 kg.
Now, a case, my lord, under section 8C and 20B of the Narcotic Drugs and Psychotropic Substance Act 1985, my lord, was initiated. And, my lord, a disciplinary proceeding was also initiated. Now, since they were in the judicial custody, my lord, now the disciplinary authority, my lord, tried to, my lord, communicate or serve certain documents, which they refused. Now, on this ground, my lord, a supplementary charge sheet was issued. Now, in the meantime, they were acquitted, and, my lord, they filed an original application challenging that charge sheet issued in connection with the disciplinary proceeding.
Which one, the supplementary one or the
Both.
earlier? Both.
Challenge both, but, my lord, the Learned Tribunal, my lord, only consider the first tribunal. There is no reference, my lord. I shall show, my lord, that there is no reference in respect of the second charge sheet, which is completely different from the, my lord, charge, my lord, indicated in the charge sheet in the criminal case. And, my lord, quashed both the charge sheets on the ground that since they have been acquitted from the criminal case, these charge sheets are liable to be quashed. Now, my lord, I have 3 points. The first point is, my lord, in all judgments, my lord, where, my lord, the Captain Paul Anthony's case were, my lord, referred to, your lordship will find that in Paul Anthony, my lord, the Honorable Apex Court was pleased to observe that where, my lord, the in a case or on an identical case where there is a criminal case as well as a disciplinary proceeding, and where the witnesses are same as well as the evidences are same, in that event, the disciplinary proceeding will not be initiated, so that the person concerned, the delinquent person, should be prejudiced, because he has to disclose the evidence as well as the he has to examine or cross-examine it. Now, here, my lord, it is completely different, my lord. We have not yet initiated. The disciplinary authority has not yet initiated, my lord, the proceeding. In every case, my lord, the Supreme Court, my lord, found that both the proceeding were, my lord, initiated and concluded, and thereafter, my lord, the Supreme Court found that yes, identical witnesses, identical evidences, therefore the disciplinary proceeding cannot be continued. This is one. Second point is, my lord, that, my lord, in the instant case, my lord, your lordship will find that the Learned Tribunal, my lord, quashed the charge sheet on the ground that on an identical cause of action, the criminal court, my lord, quashed the charge sheet in connection with a disciplinary criminal case. Now, my lord, your lordship knows, my lord, when a charge sheet can be quashed in a disciplinary proceeding matter. My lord, there are mainly 3 grounds. One is, my lord, that when there is a statutory violation while issuing the charge sheet. The second is, my lord, if there is, my lord, a jurisdictional point, suppose the person who has issued the charge sheet does not have the jurisdiction. And the third point is, my lord, that when the charge is completely vague, that it does not make any sense, then, my lord, court can, my lord, exercise of its high prerogative jurisdiction, my lord, can quash this charge sheet. But here, my lord, this is the 4th ground which, my lord, adopted by the Learned Tribunal, that since the charge sheet
or the case has been, you have been acquitted from the criminal case, this charge sheet is liable to be quashed. Now, there is no judgment on this, my lord. Now, my lord, the third point is, my lord, that the learned tribunal, as I have pointed it out, that the second charge sheet or the supplementary charge sheet was completely different. The tribunal, my lord, did not refer to that, my lord. Now, my lord, these are the sum and substance of this case. My lord, I have handed over, my lord, all the judgments, my lord, which I have referred to. My lord, may I just place those judgments once, and before that, my
You
lord,
have already placed.
Yes, I have placed.
You have
And
placed
my
them.
learned friend, my lord, referred to one judgment, that is 2024 1 SCC 175, my lord, that is, my lord, distinguishable, my lord. May I just indicate, my lord, the relevant differential factors, my lord. So far, this case is concerned, and my lord, the case which was referred to, reported in 2024 1 SCC 175. My lord, may I be permitted to place 2-3 paragraphs, my lord?
Yes.
My lord, your lordship will find from paragraph 1 that a criminal case and a disciplinary proceeding was initiated on a self-same cause of action. My lord, may I just, I'm not placing that, that is an admitted fact. Then paragraph 2, my lord, the charge has been quoted. The charge was that he has altered his date of birth. Then, my lord, your lordship will find that paragraph 3, your lordship will find from the disciplinary proceeding, my lord, found the petitioner guilty. My lord, may I just read one sentence from paragraph 4? 5 witnesses were examined in the departmental proceeding. These 5 witnesses were also examined in the criminal trial, apart from 8 other witnesses who were also examined at the criminal trial. Therefore, my lord, departmental proceeding, my lord, was allowed to continue in this case. Then, my lord, paragraph 5, your lordship will find that in the trial court they were convicted. However, my lord, the appeal court acquitted them. Then, my lord, the Honorable Supreme Court, my lord, my lord, framed the issues. Kindly consider paragraph 8. Relevant is 8.2. Questions for consideration. On the facts of the case, what is the effect of the acquittal ordered by the appellate judge in the criminal trial on the order of dismissal passed in the departmental inquiry? Therefore, my lord, the departmental inquiry was allowed to continue, and departmental inquiry passed an order of dismissal. On this juncture, my lord, the Supreme Court framed this issue. Now, my lord, relevant paragraphs now is paragraph 25 onwards. My lord, this 25 onwards, my lord, paragraph 25 onwards, my lord, your lordship will find that the Honorable Supreme Court answer, my lord, discussed with regard to question number 2, that is effect of acquittal in the criminal proceeding. My lord, so far, then the facts of the case has been, my lord, elaborately discussed. Then paragraph 30 is relevant, my lord. Well, may I read, my lord, paragraph 30? We are additionally satisfied that in the teeth of the finding of the appellate judge, the disciplinary proceedings and the orders passed thereon cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses, and circumstances were all the same. This is a case where, in exercise of our discretion, we quash the orders of the disciplinary authority and the appellate authority, as allowing them to stand will be unjust, unfair, and oppressive. Now, my lord, the basic difference, my lord, of this case and, my lord, the case which was taken up by the Honorable Supreme Court is that there, my lord, the evidences were adduced before the disciplinary authority, witnesses were examined, and the circumstances, my lord, were considered, and those were absolutely same so far, my lord, vis-a-vis the with evidences, witnesses, and circumstances in that criminal case. Now, here, my lord, the disciplinary authority has not adduced a single evidence. The presenting officer has not placed his case. No evidence has been adduced. And, my lord, your lordship knows the disciplinary authority, not disciplinary authority, my lord, the presenting officer, my lord, can adduce any number of witness, which, my lord, the delinquent officer has the right to examine, cross-examine him. And, my lord, he can also adduce any number of evidences, my lord. Only thing is, my lord, I have to give a copy of that documents, my lord, in order to, so that I can prove my charge. Therefore, my lord, that stage has not come here. We have only issued the charge sheet. We have a being the disciplinary authority, my lord, under my lord, law, under the statutory rule, my lord, namely West Bengal Services Classification, Control and Appeal Rules, my lord, we have the authority and power, my lord, to continue with the disciplinary proceeding. Now, so far, my lord, the second charge sheet is concerned, my lord, that is completely on a different footing. Therefore, my lord, that should not be, my lord, clubbed with the allegations, my lord, levied against the charge sheet issued in connection with the criminal proceeding, my lord. Now, my lord, therefore, my lord, this judgment reported in 2024, once SCC 175 are factually different, my lord. And, my lord, my last submission is, my lord, that the tribunal, my lord, by quashing that charge sheet, my lord, passed in connection with the disciplinary proceeding on the ground that they were acquitted in a criminal case, my lord. By doing this, my lord, the tribunal basically usurped the jurisdiction of the disciplinary authority. My lord, these are my submissions. My lord, I have already referred to, my lord, where, my lord, the Supreme Court allowed, my lord, the disciplinary authority to continue with the proceeding. Only thing, no, my lord, your lordship. The judgment I have annexed, my lord. Yes. My lord, the state has preferred an appeal, and that appeal has been admitted, challenging that judgment. I have also annexed that. Your lordship kindly consider the special court under NDPS Act judgment was delivered on 30th September 2022 at page 78. And my lord, page 127, your lordship will find that there are certain, I will say, my lord, statutory violation, my lord, under the NDPS Act, where, my lord, on the basis of which, my lord, page 127, your lordship will find that the NDPS court, my lord, found certain violations, my lord, at the end of the prosecution. It starts from page 78. My lord, the relevant is 127. My lord, may I just read one paragraph, my lord? 127. The first paragraph, from the first seizure list regarding the recovery of ganja of 20 kg, it appears from the contents of the seizure list PW6 and PW7. Search the accused Swapna Ghosh and 20 kg ganja was recovered. They are the constables of excise department, but from their evidence, it is nowhere found that 180 kg to 200 kg of ganja was recovered. Rather, it is established fact that PW6 and PW7 signed in the seizure list, which they did not deny. Now, thereafter, my lord, from the following this, there are certain, my lord, loopholes, I will say, my lord, this learned judge, my lord, recorded. And on the basis of this, my lord, they were acquitted. Now here, my lord, I'm sorry. My lord, the charge memo, yes. My lord, the first charge sheet is at page 133, my lord. My lord, statement of imputation is at page 136. 133 it starts. It is dated 23rd of September 2022. 136 is the statement of imputation. My lord, that the said Moharram Sheikh, excise constable, was consciously present in the raid and played a conscious role in collusion with others in the matter of illicit possession, the first charge, transportation and disposal of commercial quantity of narcotics drugs in the wake of recovery of ganja from the possession of the accused in connection with the NDPS case, and was deliberately associated with this unlawful misreporting act, subsequently unduly siphoning of the articles, and that such an act was completely unbecoming of a public servant. Now, my lord, your lordship kindly appreciate. My lord, the standard of
We are facing the same difficulty.
my lord,
Nobody can read this doc. Just see.
no, my lord, kindly consider page 133. There is a type.
So we should not read 135.
135. Oh, I'm sorry. I'm extremely
What is
sorry.
the fun in filing like this when we can't consider a document?
My
What
lord,
is the
this is-
point in filing such a document when we can't consider? Every case we find that filing is very casual, whether it is state or union offence. You don't even
my
think
lord,
about us that how we will examine the issue, how we will consider it after if you have argued and gone home, how we will consider
my lord,
these
I'm
things.
extremely sorry, my lord. There's a. May I read, my lord, page 135, my lord?
How it's pointless. Ultimately, we will not have it with us.
My lord, 135 and my lord, 130. My lord, 136, my lord, 135 and 136 are, my lord, verbatim same, my lord.
Then why there are two?
My lord, this is state. No, no, article of charge and statement of imputation.
Statement of so both
Yes.
are it is
Same, my
repeated.
lord.
Same
I
thing.
136, my lord. Now,
This is legible. Yes.
yes, 136, my lord, may I please, my lord? I'm sorry, my lord.
Yes.
That the said Moharram Sheikh, excise constable now under suspension, was consciously present in the raid and played a conscious role in collusion with others in the matter of illicit possession, transportation and disposal of commercial quantity of narcotics drugs in the wake of recovery of ganja from the possession of the accused in connection with the NDPS case number such and such, dated 6 September 2017, and was deliberately associated with this unlawful misreporting act, subsequently unduly siphoning of the articles, and that such an act was completely unbecoming of a public servant. Now, my lord, your lordship kindly appreciate, or your lordship knows, my lord, the standard of proof in a case of criminal case and, my lord, in a case of a disciplinary proceeding.
What is the charge?
Charge is, my lord, three
Directly
charges:
associated
illicit
with this.
possession, then third line, my lord, illicit possession, transportation and disposal of commercial quantity. These are the three charges. Now, my lord, for a disciplinary proceeding, my lord, the requirement is preponderance of probability. Whereas, my lord, in a criminal case, it's a conclusive proof, my lord.
Illicit possession, transportation, and disposal is a charge.
That is.
And how one can respond to this?
My lord, that they have denied. Now,
you're not asserted
now, my lord, it is up to the prosecution that how they will prove the charge. It is completely.
First, there has to be a charge capable of being disputed or denied or met by the delinquent. How does one meet such an allegation that you are guilty of illegal possession and disposition? Possession of which substance? How much? Transportation by which mode? From which place to which place?
One of that.
What is this? What kind of a charge you have framed?
One of the charge sheet has not been challenged on the ground that.
Oh no, but when it is before us, we are the writ court. We are asking you this. It has not been challenged.
There is a reference of the case number such 136 of 2017.
Very good. And how will you establish this charge in a proceeding?
It is up to. I will not establish. It is the prosecution they will establish.
No, you are the person who has issued the charge memo. You are the employer.
Yes.
Not a charge memo. You are guilty of illegal possession, transportation, and disposal. Which substance? Where? How much? Nothing.
Now, my lord.
Where is
not
the
very
subsequent
happily
charge
drafted,
memo?
my lord, but the question.
Now, where is the subsequent charge memo?
The subsequent is at page. My lord, page 140, my lord.
This is after the acquittal.
After the. Well, this is dated 3rd of November 2022. They were acquitted on 30th September 2022. My lord, here your lordship 140 starts, my lord, then page 142, my lord, annexure 1.
So this is only regarding their willful disobedience.
Yes, yes, they refuse to accept this. Therefore, my lord, page 142, your lordship will find that they have framed the charge. Now, this has not been referred to, my lord, at all by the tribunal.
This is a consequence of the first. They are not severable.
My lord,
if you are trying to serve a charge memo which does not make out anything, where is the question of the second part?
My lord, there is one thing, my lord.
If we hold that, yes, that charges to be then.
My lord, on the date when, my lord, the first charge sheet was issued, my lord, one cannot say that since this is a vague charge sheet, therefore I will not accept. Therefore, my lord, on the date when it was refused, or on this ground alone, this refusal itself is a misconduct.
Where is the narration? When they have refused? When you have tried to give it to them? What is it that you are trying?
That has been, my lord, your lordship will find. My lord, page 140. Kindly consider, my lord.
At the first page.
First page, my lord. My lord, first, second. My lord, the sentence starts with, whereas at the time of institution of the inquiry, my lord. May I read, my lord?
Just a minute.
Whereas at the time of.
Just a minute.
I'm sorry.
So non-acceptance of a charge memo is misconduct.
Yes, my lord.
Where is that? Let us see. Where is that in the West Bengal?
There is a duty, rules with regard to duty and obligation.
Where is that? Under which provision that?
My lord, there is,
There are
there is
four
one
attempts.
West
There are
Bengal
four.
services.
There are four attempts to
Yes.
serve notice.
Yes.
First, while they were in judicial custody, the
At
jail.
this point of time, through the superintendent, they tried.
Let us say what we are saying. Then you may correct if we are wrong. The jail superintendent said that they have all refused. Second time also similar response. Third time you sent at home by speed post. Served on one or two, maybe the remaining they refused to accept.
Yes.
Fourth time you sent a messenger. Again they refused to accept. So this refusal to accept paves the way for proceeding ex parte or is a cause for a charge itself. Under which provision non-receipt of a charge memo would become an offense? Let us see.
Within the purview of.
Let us see.
Yes.
That's why we are
My
saying.
lord, there is one rule, namely West Bengal services, duties and obligations of it.
So
And
let
that
us see.
rule
Let
is-
us see. Because here it is to be guided by the disciplinary conduct and appeal rules. Because service of notice or service of charge memo is under the disciplinary conduct and appeal rules. So what is the provision? Let us see that first.
Yes.
The West Bengal disciplinary control and appeal rules.
West Bengal service manual, my lord, not in WBSR, my lord. West Bengal service, your lordship will not find.
Oh.
My lord, in the service manual, there are four, there are different rules. One is DCRB rule, then CCA rule, and this rule is also there, my lord.
No, there is a West Bengal disciplinary conduct and appeal rules.
Yes, my lord, the proceeding is under this CCA rules, classification, control and appeal rules.
Yes.
And there is other rule, my lord, that is duties and
So
obligations.
first, let us see the classification,
Yes,
control and appeal.
Yes, that is. বইটা দেখাতে হবে ম্যানুয়াল May I hand over the CCA rules? I'm very sorry, Mala. There is only one copy. I should ask my junior to bring one.
West Bengal. Here it is not there. Must be behind somewhere. This is the name. Get both the rules. Actually, we will have to rise because there is a division bench of His Lordship with another honorable judge. Therefore, we cannot wait right now. Get two copies of both the rules. But we will examine that issue also. Once we are seeing it, we must see everything. All India, named West Bengal. That is all India. We are asking for.
Yes, my lord. Yes, yes. Yes, yes. My lord, there is a book, namely West Bengal Service Manuals. Your lordship will find all rules, my lord, there. West Bengal Service Manual. লিখে দাও তো ওয়েস্ট বেঙ্গল সার্ভিস ম্যানুয়াল তোমার এটা খোলো ওটা খুলে তার মধ্যে দুটো রুল লিখে দাও ওয়েস্ট বেঙ্গল সার্ভিসেস WBS CCA রুল আর এইটা West Bengal Services duties, rights and obligations of the government in respect of the Shukriya. It's verified, but I'm asking. Yes, my lord, I have given. Get it from the library. Get it from the library. 2 copies. And we have to fill it here.
Item number 13.
My lord, 13, 14, 15 identical, my lord. Yes, 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 my lord. 15. Great.
12 to 15.
12 to 15. Gratefully.
Yes, sir.
Item number 16. Well, in this matter, Mr. Komal is appearing on the other petition. Another accompanying circumstance, he has to leave the court due to his family problem. Kindly make it on Monday, subject to also.